I want to start by asking you, this is a case and this is a judgment which we've all been perhaps expecting, and it is in a way something that has defined the way politics and the discourse is there in our country. When this kind of a judgment comes, where they say that the agency has failed to prove anything, is it disappointing for someone like you?
Well, very disappointing. It's a damp squib, this judgment. It was much anticipated, and it's been a great disappointment. 2,000 pages showing that the CBI couldn't prove something as elementary as the presence of the accused, the decision of, the presence of a conspiracy. Even though this was much touted, there was plenty of evidence of this, both in the media, even before the event and after the event. There's been plenty of evidence of this. To say that there was no evidence available because they couldn't produce it in court is very, very disappointing.
I want to start off by asking you, Dr. Chaudhry, is the fact that they said that there doesn't seem to be a conspiracy. It seems to be an act that was done by antisocial elements. And what is interesting is the fact that they say that these 32 people, and a lot of us in the media are used to, we've seen all the witness statements that have come over the years where they say that many were accused, and the CBI said they made inflammatory statements. They say the court says they in fact tried to stop these antisocial elements. What are we supposed to make of this kind of an announcement?
To say that this is a crime committed by antisocial elements is extremely surprising. In fact, I think it's an insult to our intelligence. I don't think there is any doubt in anybody's mind that this was an ideological crime. It grew out of a movement to construct the Ram temple at that space, and therefore the Babri Masjid had to be demolished. There was a great deal of propaganda leading to the demolition of the Babri Masjid, and it was a political event. It was part of a political campaign. There was a Rath Yatra which preceded it. So then say that this demolition has been done by antisocial elements. In fact, I think at one stage the judge even indicates that there were rumors of dacoits and criminals present in the crowd. I wonder what benefit could dacoits and criminals get by demolishing this decrepit old mosque? Let's be very clear about this. This is not a crime committed by dacoits and criminals. This was a crime committed by This was an ideological crime. Let's be very clear about it. You want to call it a crime, you want to say it's something else, we can debate that. But this was done for ideological reasons. And there should be no two things about this. I mean, we should not lie to ourselves. The essential nature of this act has to be recognized. That's the first thing. Now, it is certainly possible that a crime may be committed spontaneously, where people get together not intending to commit a crime, but then a crime is committed either by individual acts or by people, a coming together of a common intention. Or you can have a crime which is committed on the basis of a meeting of minds, an agreement beforehand, which is what is called a conspiracy. Now, in this case, there is plenty of evidence of a conspiracy. You have the massing of men, you have the arrival of karsevaks, you have accommodation being made for karsevaks, their living and food arrangements are being made over there. You have the massing of material for karsevaks. You have the giving of inflammatory speeches. You have the slogans that are being made for a long time, Mandir yahi banayenge. And then after all of that, you have the presence of the accused at the spot. And then to say that this was a crime which was not pre-planned, but which just happened spontaneously, is, I think, to try and take us all for a ride. No one is going to accept this. Not anyone with a shred of intelligence or understanding about the law will ever accept this in his heart of hearts.
We all know that the CBI has messed up cases before, so that wouldn't be a first. So when you say no one will accept this, their kind of summation and their kind of what they've taken away from this, is it the CBI's fault, or is there something much larger at play over here? The CBI has the one, for example, you talked about the inflammatory speeches. What I just want to point out to our viewers, what I also want to point out is by looking at that portion of the judgment that I read, and they referred to it about the leaders who were on stage. they point out and say that the CBI failed to get recordings which were verified by a forensic laboratory, and they failed to get voice samples which then, so they were unable to get voice samples, so make a kind of link between voice samples and the recordings that were there. So in that case, is it the court's fault? Is it the CBI's fault? Who's really at fault over here?
When an attempt is made at adducing evidence and the other side objects, the judge has to rule on whether that evidence is admissible or not. In the event that, let us say, you are trying to adduce a document, or let us say a film, and the judge rules that the document adduced is a photocopy and not an original, or that the film that is being sought to be proved has not been duly authenticated and the original is not produced, and therefore the document or the film is not admissible because it is a secondary evidence and not primary evidence, the prosecution has various options open to it. At that stage, the prosecution can say, well, all right, we'll get the primary evidence. Or the prosecution may say, yes, this is secondary evidence, but we are allowed to lead secondary evidence in exceptional cases, and this is one of them, and for the following reasons, the secondary evidence should be allowed. Or the prosecution can appeal that verdict of the judge refusing to exhibit that piece of evidence. This is elementary. This is extremely elementary. Any first-year law student will tell you this. If a judge has ruled a piece of vital evidence as being inadmissible during the trial, you have the whole of the rest of the trial to remedy that. You can get the original evidence, or you can make an application to lead secondary evidence. There's so much that can be done. If this has not been done, and you have rested content with your attempt to lead secondary evidence which has been rejected by the judge for lack of authentication, I wouldn't say it's incompetence, because this is too elementary to be incompetence. It smacks of collusion.
Collusion between? Could you clarify on that? Because
yes, certainly.
As someone, I've covered the CBI also. Yeah. So, the CBI, for a lot of its things, it goes back to the government. It's actually an agency which is under the Department of Personnel and Training. So while it is meant to be autonomous, there are certain things when it comes to getting their officers, when it comes to moving, when it comes to getting legal opinion, that's when the interaction with the government comes. So you're saying collusion between?
The government, which is represented by the CBI, let us not be under any illusion, the CBI is the government's agency. It prosecutes on behalf of the government, is under the control of the government. The collusion I mentioned is between the government through the CBI with the accused.
Suppose we give CBI the benefit of the doubt and they approach you. This is all hypothetical. If they approach you and they say, we really want to get all the people, we still believe that these 32 who've been acquitted, they are the ones who did it. They are the ones who incited, and they are part of the conspiracy. And the VHP leaders who have been freed, they are the ones who got all the car sevaks together. How would you, as a lawyer, out of this kind of complete acquittal, how would you go about, what is the way to go about building a case so that the High Court overturns this acquittal?
Sunetra, I'm so happy you asked me that question. Well, the way to do it would be this. The first thing they would need to do is to make a list of all the evidence that they tried to adduce in the trial, but which was rejected by the judge for various reasons, because it was either secondary evidence, not authenticated properly, so and so on and so forth. Make that list, then make an application in the High Court under Section 390 or 391 of CRPC, I forget the section, which allows the court in appeal to order the taking of further evidence, and then make an application to the High Court asking that they be allowed to lead further evidence whereby the primary evidence of these documents and this video footage be adduced before the court, or an application be made for secondary evidence, and these items of evidence which were rejected at trial be then admitted in evidence. This is the first thing that should be done. If there is an ounce of sincerity in this prosecution, the CBI will make that application in the High Court. This is the test for the CBI.